Some people see non-compete agreements as an essential business protection, while others see them as career roadblocks. So, what should you think about when considering the use of non-competes? A non-compete agreement is a legal contract between an employer and an employee that restricts the employee from working for competitors or starting a competing business for a specified period of time, typically within a specific geographical area after leaving the company. Employers use them to protect trade secrets, customer relationships, and their competitive edge. But here's the catch. Non-competes must be reasonable to be enforceable. That means fair time limits, geographic restrictions, and job scope. Some states, like California and Minnesota, have banned them entirely, while others, like Florida and Texas, impose strict guidelines. If a non-compete isn't the right fit, other restrictive agreements like non-solicitation agreements or non-disclosure agreements can still protect your business without limiting employee mobility. With changing laws and increasing scrutiny, employers should review their agreements carefully. Always consult an employment attorney to ensure your non-compete is fair, legal, and enforceable. Clients of Frank Crum with the Frank Advice HR Consulting Service can reach out to their HR consultant for guidance on considerations when regarding non-competes, as well as employment laws and other HR best practices.